will be explaining about the main section of theft offences under the Malaysian Penal Code. So basically, it was covered under section 378 of the Penal Code, where it is likely the same as in the common law explanation. So the provision generally defines the offences of theft where one intentionally acts dishonesty on moving the property out from the possession of the other person without the person concerned. So as stated, the fourth element of theft occurred when it was proven that there was a dishonesty intention in taking any movable property out from the other person's possession without their consent, while the physical element of theft was established when the accused reacts in moving the property in order to fulfill his intention. So basically, dishonesty is the most important requirement under theft, where the intention to cause wrongful gain or wrongful loss of any person. The act of dishonesty on taking the other person's property at the time of moving it out from their possession without their consent is considered theft already.
Except the dishonor intention, there are also other parts of the element that need to be considered in theft offences, which is the act of moving. So moving the property, although not out of the possession, is enough to constitute as theft. But in the event where the shoppers select an item from the shelf of the market, is not considered as theft. And theft happens only when the shoppers leave without paying. So following, the said property must also be a movable property and is defined under section 22 of the Penal Code as a corporeal property, except those attached to the earth. However, it's pertinent to note that once the immovable property has been severed from the earth, then it's capable of committing theft. And it's noteworthy that the theft offense is an offense against possession rather than ownership. So depriving one from his possession is enough to constitute theft. And possession can namely be in possession in fact or possession in law. So after knowing the physical and fourth element of the theft offense, here comes an interesting question. So it's for us to think about whether freeganism is considered theft in Malaysia. So freeganism is the practice of taking and using the items that other people, shops or organizations has thrown away, or we known as karang-guni. So generally, abandoned property is not owned or possessed by anyone. Thus, taking the abandoned property would not be theft since the owner would have abandoned the possessions of the item. But there may be a twist. As there is no local case in Malaysia, we take the UK case as reference. So in Ricketts versus Basildon Magistrate Court and William versus Phillips, both of these cases illustrate that the item in the dustbin on the private property are not abandoned property. Freegan may still commit theft if they rummage through the dumpster in the shop because these dumpsters are still on the private property and are not publicly accessible to others. So in Ricky's case, a man was convicted of theft for taking the clothing for the bins outside a charity shop. So although the clothing has been discarded, they are not abandoned. The owner actually intended to take the bags of the clothes for charity. Thus, it appears that mere disposal of the item is insufficient to constitute abandon. So, whether taking such property is constituted as theft or not become a question. The elements of dishonesty in section 378 of Penal Code is therefore significant in determining the theft conviction in freegan. It needs to prove that the freegan are neither objectively nor subjectively dishonest in obtaining that property. But if he takes the items from a public bin, then there will be no theft, as he believes that the person to whom the property belongs cannot be discovered by taking the reasonable step.
So as for the punishment, there were few punishments for theft offences. So firstly, Section 379 of the Penal Code, where it stated the general punishment for theft offences, where the accused may be punished with no more than 7 years imprisonment or with fine or with both. As subsequent offenders, the accused may be punished with both imprisonment and whipping or fine. Second, we will see Section 379A, where the accused who commits theft or stealing motor vehicle or component part shall be punished with imprisonment not less than 12 months and not more than 7 years and fine. So third, we will see Section 380 of the Penal Code, where the punishment stated is for the theft offences of dwelling house. So this provision covers the cases where the accused act the theft offences in someone's house with their consent. So as stated, the accused may be punished not more than 10 years and fine. Also, for the second offences, shall be punished with imprisonment and shall also be liable to fine or to whip. Next, the punishment for theft offences resulted by a clerk or servant of property in the master's possession is stated under Section 381 of the Penal Code. So this provision defines the punishment of the accused where he acts dishonestly in stolen goods under terms of the employment. So the accused shall be punished with imprisonment for a term which may extend to 7 years and shall also be liable to fine. Last but not least is the punishment for theft offences where the accused is making preparation for causing death or hurt in order to commit theft. This punishment was defined under Section 382 of the Penal Code. So this section usually covers the cases of accused that were armed but do not really use or threaten to use the arm. The accused shall be punished with imprisonment for a term which may extend to 10 years and shall also be liable to fine or to whipping.
One of the advantages that can be found under Section 378 of the Penal Code is any movement of the property that is caused by the accused is already sufficient to constitute it as theft offence. The offence of theft is said to have been completed immediately after a movement to the property, and here property is not necessary to be taken out from the person's possession. Plus, it is not necessary to determine how much of the property has been moved by the accused, and thus small movement of the property made by the accused is also enough to convict him for theft. So it is favourable towards the prosecution to prove easily that the accused has moved the victim's property and can convict him for the theft. It also reduces the prosecution burden to prove on the physical element. And here it can be referred to in the case of Raja Muhammad and against R, where the court held that the accused's action of moving 2 dozen glasses from his employee's ground floor storage to a box on the first floor with a dishonest intention to move the property was enough to make him liable for the offence, even though he did not have to remove them from the victim's possession. Moving on to another advantage, the provision is more focusing on the subjective fault of the accused in regards to matters of consent. Here, the lack of consent is recognised as part of the fault element. The rationale of why it is said to only focus on the subjective fault of the accused is due to the prosecution does not need to establish that the victim did not consent. Instead, the prosecution must prove that the accused meant to take the property without the victim's consent. Thus, rather than asking whether the victim consented to the taking or not, the relevant issue here is whether the accused intended to take the property without the victim's consent. As regards to this, the right of the victim will be better protected as it shows that this provision is more favour towards the prosecution, in which the matter of consent must be proven only on the part of the accused. Finally, another advantage that can be found is that the general punishment under Section 379 is appropriate to be imposed on the offender once he is found guilty for the offence. The punishment of the theft can be said to be in correspondence with the seriousness of the theft. Under this provision, the theft offender can be punished with imprisonment for a term up to 7 years or with fine or with both, and if there is a second or subsequent offence, the offender shall be punished with imprisonment as well as fine or whipping. This deterrent sentencing law that has been passed is a reaction of the legislature based on the society's view and public interest to remove judicial laxity and punish all those who break the law equally. Plus, the provision also provides further punishment for those who commit subsequent theft offences, and this can help in preventing theft offences from happening again and can give awareness not only to the offenders but also to the rest of the community. This can be referred in the case of public prosecutor, again Wong Chak Heng, where the court held that the punishment under Section 379 that has been imposed on the accused for committing 2 subsequent theft offences is appropriate and necessary, as it is compatible with the duty to protect the public's interest as well as to punish and deter the criminal offence.
The first limitation is different interpretations on the definitions of theft provisions. The primary interpretations denote that the physical elements of theft only involve the moving of the property, and the fault element of theft offence will be that the accused has dishonestly intend to take property out of the person's possessions without that person's consent. Meanwhile, the second interpretation is different from the first, where the fault element consists only of being dishonest and other requirements forming part of the physical elements. The most substantial reasons for having two different interpretations of the provisions on the ground that the sections 378 of Penal Code does not specify the physical and the fourth elements of the theft clearly. As a consequence, the blurring of distinctions between actus reus and mens rea can generate confusions. For example, this leads to prosecutor to confusions on proving actus reus and mens rea while charging the offenders. The second limitation is insufficiency of a clear definitions. This can be seen in terms of various interpretations of the word property in the Penal Code. First, sections 378 of PC, Penal Code, which is set up general offence for theft. In these provisions, the word movable property has been used, which was defined as a corporeal property of any kind, excluding land and anything that permanently attached to the earth, as mentioned in sections 22. Meanwhile, sections 318 deal with theft in a dwelling house. This provision used the term custody of property, but the definition of it was not clearly explained. Additionally, in section 390, which deal with the offence of robbery, the definitions of the word property in these provisions was equivalent to the word property in sections 378 of the Penal Code, that's confined to movable property. Based on the above analysis, there is uncertainty within the law. As the word property is not clearly defined under the Penal Code, it is difficult to apprehend clearly what would be classified as a property within the penal law of Malaysia. By interpreting further into the provisions, sections 378 of Penal Code has excluded immovable property as the matter of theft because the provision itself only mentions movable property. If the movable property is stolen, it cannot be covered under the state's provisions. This in fact leads to the lack of recognition or acknowledgements of important and value online resources like informations, database, keywords, meta tags as a property. However, the problem arises when the protections on online resources is insufficient, which exposes them being vulnerable for being misused. These present cyber-specified provisions only focusing on its main task, which is regulating illegal acts and activities occurring daily in the cyberspace, rather than protecting the online resources. The lack of adequate legal protections for these online valuable resources seriously affecting the extent of confidence of the internet users.
One of the ways is by widening the scope of property to cover not only the matter on the movable property, but also the matter of immovable property such as online resources. The idea of amending the definition of the scope to include both movable and immovable is a wise idea, as nowadays the property is not only limited to the movable asset, but it also includes the immovable and intangible assets such as virtual currency and more. The development and amendment in Singapore may be pondered upon, whereby the definition of property in the Singapore Penal Code has been widened, where it's not only not confined only on the movable property, but the code also includes the immovable property, intangible property, and virtual currency to the definition. Along with the amendment, section 378 of the Singapore Penal Code has also been amended, where the code provides an additional explanation and illustration. It stipulates on the moving of intangible and incorporeal property from one account to another account. This explanation also can be seen clearly in additional illustration Q of the section. Theft law in Malaysia can also be improved by detailing more on the value of the property under the Penal Code. Section 378 of Penal Code does not provide on the details on the property values that can raise the offence of theft. Considering the property without taking the value into account is inconsistent with Section 95 of Penal Code, which is stated that it is not an offence if the act brings slight harm, for there is a need to have a specific property value in Malaysian Penal Code to know the minimum value where the offence can be raised.